The continued data privacy conflict between the European Union and the US has a new causality. Following a probe by the Irish Data Protection Committee that is responsible for regulation of Meta in Europe, the European Data Protection Board has slapped a massive $1.3 billion penalty on Meta. The EU regulator alleged the processing and storage of EU personal data in the United States violated the European Union's data privacy law, known as the General Data Protection Regulation or GDPR. The law distinguishes the information that can and cannot be transferred within countries or between international organizations. Under the GDPR, so far, this is the largest fine that has ever been levied. The European Data Protection Board has directed Meta to stop processing of personal data of EU users in the US within the next 6 months. The latest penalty on Meta is consequent to a long battle between US rule on accessing data and the privacy rights of Europeans. The concerns about the US National Security Agency's authority to access personal data of even non-Americans from US servers have inspired the European regulators to take strict measures. But transatlantic data movement is critical for the $7 trillion worth of economic activity as of March 2022 and around 5,300 businesses that rely on seamless data transfer across the Atlantic. The latest development highlights the continued uncertainty around how global businesses may legally transfer EU user data to overseas servers. Let's turn to Mehak Khanna of Khaitan & Khaitan to understand India's existing laws in relation to processing and storage of Indian users' personal data abroad.
There are these certain information technology, reasonable security practices and procedures and sensitive personal data or information rules 2011. So for the sake of discussion there, let's call them these 2011 rules. So under these rules, any body corporate and it can be any company like, a Meta or Twitter or any company based out of India, it can, transfer sensitive personal data or information to any other body corporate located in any foreign country. But there are two conditions to be met for that. Firstly, it needs to ensure that the same level of data protection is, adhered by that body corporate which is mentioned under these rules. And secondly, it needs to transfer the data if the data subject has consented to such a transfer, or if the under the contract between the corporate and the data subject, this is something which is essentially required for the performance of the contract. So basis these conditions, the data can be transferred.
It's about time global businesses based in India should be careful about transferring and storing user data to foreign servers. Any breach may lead to a fine of up to 5 lakh rupees or 3 years of imprisonment for its authorized representative or both. India is also working on a new digital data protection bill which is scheduled to be presented in the upcoming monsoon session of the parliament. What change can the proposed bill bring up regarding user data management?
What is going to be the position in the proposed digital personal data protection bill, which is still pending in the parliament? Hopefully we will sort of see the final draft introduced in the monsoon session, and that could be passed. There are, of course, certain restrictions there in terms of transfer of critical personal data. So all critical personal data, which has not as such been defined as yet in the law itself, but would be defined and identified subsequently after the passing of the bill by the central government. There are specific restrictions and there are hard data localization requirements for that.
Experts also point out that instances like imposing fines on Meta will drive India to strengthen its rule to safeguard data of the Indian users. Big techs like Meta, Google, and Amazon will have to make the required changes in their platforms and applications to comply with the new regulations.
Obviously, what's being the regulatory position elsewhere in the world, I think it would become a precedent in other countries. So we are already seeing extensive discussion in the regulatory, fraternity which is talking about similar fines being imposed on in other parts of the world as well. And probably, yes, once we have the relevant provisions in India, India could also follow suit. Also, from a purely company perspective, Meta could actually start in their policies, and which could impact Indian users as well.
We are a few months away from getting clarity on the nuances of the proposed Digital Personal Data Protection Bill that the government is working on. Meanwhile, notwithstanding the regulations, experts emphasize that global companies should voluntarily incorporate protection of user data in their DNAs.
If you like this video, share it and subscribe to Business Standard. For more news, views and insights, log on to www.business-standard.com. Do also follow us on YouTube, Twitter, Facebook, Instagram, Telegram and LinkedIn.